ইখন বেছি ইফালে গ'লগৈ নেকি, but it's all right. Morning. Yes.
Yeah, please, Your Lordship.
Yes,
With
Mr.
regard to
Prasad.
item number 15,
50.
15.
Yes.
I'm led by Senior Counsel Mr. D.K. Mishra. Your Lordship may not be.
Not by me, huh? 15. 15, na?
15.
All right.
Obliged.
Wait, please, Your Lordship. I beg to mention item number 30, Your Lordship. Tabli list, Lordship. Please discuss, Lordship. 30, Lordship.
30. What do you want?
Not please, Lordship. Withdraw, Lordship.
Withdraw. You are Mr.
M. Mondal, Lordship.
Aspirate, Mr. M. Heard M. Mondal and KK. Mr. Parasar, you are there? KK Parasar, APP, okay? Mr. Mondal, so and so submits that he has instructions from the petitioner not to press the instant bail application and accordingly seeks withdrawal of the same. Prayer is allowed. The bail application stands withdrawn, stands dismissed on withdrawal.
Obliged.
May I please, Your Lordship?
Yes,
Item number
Prasad.
21, 22, my lord. I am for the respondent, he's. We have
20
personal difficulty, 21 and 22, Lord.
21 and 22. As jointly prayed for by the learned councils appearing for the parties, relist when after
Maybe subject to toxic convenience, madam, maybe on Thursday.
after a week on a date to be fixed by the registry.
8, my lord, on 8 Thursday.
All right. Not on 8, registry will fix a date. I have said after a week. Yes, next.
Obliged.
Please, Your Lordship. And I'd like to mention item number 32,
33,
my lord, 32
32. Yes.
here today, my lord. Let the matter come.
Your
on
name?
6 S. Bapatra Gohai.
As prayed for by Mrs. S. Borpatra Gohai, learned counsel for the petitioner, list this matter after
6,
relist on 6/5/2025.
taken the consent of the other side of.
You say that so and so with consent of the other side seeks adjournment on the ground that Mr. D.P. Chalia, learned leading
Yeah,
counsel
madam.
in the matter for
R.C.
the
Bapatra Gohai.
so who is going to appear?
The Dr. R.C. Bapatra
Okay,
Gohai.
Dr. R.C. Borpatra Gohai is having personal difficulty. Okay. Yes, next.
I wish to mention item number 10, my lord. Appeal and matter, yeah, respondent say matter.
27. Yes, what do you want?
For 10 days, my lord, parties newly engaged.
Mr. Datta, you are there in this case.
Can be on 15, my lord. I've got some urgency.
As jointly prayed for by the learned councils for the parties, relist on
15, my lord.
15 so and so.
Obliged.
Yes, Mr. Mahajan,
Yeah, please, Your Lordship, my lord. Document for listing, my lord. This is
listing of
EB, my lord. This is more than 7 years and special act, my lord.
special act. I think there's a senior bench, Mr. Mahajan.
But it is more than 7 years. I went there, my lord, and
Is it? You leave it, but he'll verify, subject to verification.
my lord. Obliged, my lord.
I love এখন bench can special act লৈ আছে. Yes, please call the list.
Please, Your Lordship.
Item number.
28.
Your name?
S. Paul, Your Lordship.
Mr. S. Heard Mr. S. Paul and KK Das, APP, huh? Mr. S. Paul, learned counsel for the petitioner, submits that he has received instructions from the petitioner not to press the instant anticipatory bail application and accordingly seeks withdrawal of the same. Prayer is allowed. The anticipatory bail application stands dismissed on being withdrawn.
Please, Your Lordship.
Scan copy or case diary?
Copy, Lord.
Scan copy. Call for scan copy from the court of
Special Judge Sribhumi, Your Lordship.
Special Judge Sribhumi. List on.
It may be given, Your Lordship.
List on.
Lordship on 8,
8.
8 or 9, it will not come. Lord.
Just have a look at the court.
But it is-
Just see the court, call from to registry.
13.
Yes, next. Case diary or scan copy?
Can copy from district and sessions and.
Call for the scan copy from the Court of District and Session Judge.
Go.
Amin Gao. List on
Lordship, here we have also filed one additional affidavit today. That may also be tagged.
MS Som. Learned Counsel for the petitioner submits that an additional affidavit has been filed today in the matter. However, the same is not on record. Let registry verify and place the same on record.
Amount.
Date delay na? Yes,
Scan copy may be called.
scan
for.
copy,
Yeah,
same scan copy and date diok.
Additional district and session judge number 3.
Additional district judge number three.
Number three.
Yes, anything else?
Already a co-case has been granted.
Sorry?
bail. Already co-case has been granted bail.
No,
so-
this is a commercial quantity. Doesn't he have a
My
right
prayer-
to
my
oppose?
prayer would be short date maybe.
Give a date, short date. Yes. Scan copy. Scan copy, list on. Which court?
Dhubri special judge.
Dhubri special judge. Huh? To registry all of this, huh? Case diaries, huh?
Scan copy.
Scan cop, call for.
Point your lordship granted several bail matters.
Mr. Biswas, Mr. Biswas, please. It's a commercial quantity.
Yes, madam.
We will consider your case, but let first the documents, let them first produce the scan copy. Scan copy of so-and-so, call from the court from so-and-so through registry, list on such and such date.
15.
Commercial quantity.
Yes.
Scan copy.
Yes, sir.
Scan copy from the court of
Additional session judge number 2, Kamrup.
additional session judge number 2, Kamrup. Through registry, list on such and such date.
Wait, please, your lordship. Lordship, commercial quantity, lordship, in this case, lordship.
Note, case diary?
Scan copy.
Scan copy from the court of,
Amingao, lordship.
from
District and
the,
session judge. District and session
from the
judge.
court of district and session judge Amin Gao. Through registry, list on
Obliged, lordship.
POXO.
Yes, so 3 years bail application. But my
Issue notice, call for case diary, list,
14.
Huh?
14 on.
call for case diary
Okay.
fixing on 14/5/2025. Steps in respect of respondent number 2. Respondent number 2 stroke informant be taken through the registry of this court in terms of the decision of the division bench rendered in the case of so-and-so versus so-and-so in so-and-so. List on, that I have already given,
Achha.
list accordingly.
POXO.
Same order, but in the steps you mentioned within within a week you mentioned, because tomorrow, 3 days steps. How much time will you take for steps? 4 days.
On 16.
Within 4 days.
Did need to be called for.
Mentioned it last. Same order, okay? Fixing on 16.
16.
16. Same style, that order. 22C. Yes, scan copy.
This is the, your lordship,
This
I
is
will
the
claim for protection.
Uh-huh.
Your lordship has already given protection.
Lordship, this is an NDPS case. His contention is that he purchased the vehicle from the contraband was seized.
But
Lordship,
here also commercial quantity.
commercial quantity. Lordship, here I propose that let the petitioner be appear before the investigating officer.
I will.
In the meantime, case may be kept pending.
Yes.
We'll submit
So then I'll give him interim.
but subject to date may be fixed. Will not
Of course.
he should appear before the authority.
When, Mr. Biswas?
Any date, but he will come from Calcutta, madam.
Heard Mr. S.C. Biswas, learned counsel for the petitioner. Also heard Mr. K.C. Kayal, learned standing counsel, NCB. Are you a special prosecutor?
Yes, Lord.
Within bracket special prosecutor, huh? This is an application seeking pre-arrest bail under section 482 of BNSS 2023 in favor of the accused petitioners. One petitioner?
Yes, earlier your lordship was granted one.
All right. No, because it says petitioners in the cost title, so I get confused. Petitioner, I, Ajay Kumar Tiwari, who is apprehending arrest in connection with NCB crime number 9/2024 under section 8C, read with section 22C and 29 of NDPS Act, so and so, arising out of the FIR lodged by one IO Sanjeet Kumar. Heard both the learned counsels. Considering a call for CD fixing on.
Date may be as per convenience of the petition.
No, for the court. Before that, he will appear, but then the CD has to come. So that is why I'm asking when.
If, on 13th of May,
13 May, then we will ask him to appear when. If it's 13th May, you want it in the court.
7 or 8.
Let us fix it on 16. Fixing on 16/5/2025. Considering the facts and circumstances of the case, it is provided that in the event of arrest, interim pre-arrest bail, so and so, satisfaction of the arresting authority, and subject, of course, to the following conditions. Number one, you say appear before the investigating officer on
7 days.
The
With-
date may be kindly be fixed.
say after 7 days, give the date on such and such date,
On 7th of May,
7th May.
8, let should be 8, because on after 7 days.
On 8 May 2025, failing which from the 9th, okay? And all the other NDPS conditions and list accordingly.
much of.
Yes, Ms. Bhattacharya?
Relates to non-payment of retirement.
Yes,
benefit
Mr.
loss.
Dhor?
I have an instruction, my lord.
You have an instruction.
My lord. I'm just placing
Oh,
it.
this is that case.
Yes, Lordship, non-payment of retirement benefits, Lordship.
At the very first instance, I just want to reiterate, my lord, we are not responsible for their salary, retirement, nothing, my lord. We just give granting aid to them, the AKIB. My lord,
Who is-
this
who is
24, 25,
responsible?
we have given them some 12
Who is responsible?
Khadi board, my lord.
Hmm?
Khadi board, my lord. They are
Khadi board.
Khadi
They
board.
are a respondent here.
Yes, my lord.
He is the employee under the Khadi board, Lordship.
So you are appearing representing Khadi board. Okay, now the instruction that was specifically called is as to what had happened to the supplementary demand which was to be laid in the monsoon season.
My lord,
Now, as
along with that, we have given more.
that has already given.
Yes, my lord. In one, you will say, my lord, granting aid received by the Assam Khadi Village Industries Board during financial year 24-25.
Yes.
This current year, my lord.
Yeah.
This is total, my lord, 12
Then-
12 crores 17 lakhs 87,138.
All right.
So in thereafter, my lord, the secretary writes that the regular granting aid budget has already been released to AK VIB
What
as
is
stated above.
AKVIB? The board.
Assam Khadi and Village Industries.
Assam-
Yes, then what? Why are you not paying?
It is the amount my learned friend is payments.
My lord,
We a proposal for a supplementary budget, my lord.
No, it is saying, it is also mentioned here that no formal proposal has been received during the financial year 2024 to 2025 for supplementary demand against the petitioner claim as per timeline fixed by the finance department. It may be mentioned here that the contributory fund is maintained by the AKVIB only. Hence, the eligible amount against the CPF contribution may be released from the corpus where the CPF contribution has been maintained.
Yes, my lord. My lord,
Why is this not being done? Why this person has to run from post to pillar for her pensions? He is, no? Petitioner is she, right?
He, 2016 Lordship, he is running.
Why it has to be
there is
done?
no difficulty in
Otherwise, you have your officers in the court. Let us find out what is wrong.
what I would like to point out, my lord. That the amount that has been said, my lord, that is for the regular payments of the salary. And regarding the statement made in the no proposal have been submitted, but I will like to the proposal that is on record, my lord. Page 43, my lord, kindly.
You see, if this is the controversy, then we'll have both the officers. Mr. Dhaur's client as well as your client. Let them come to court and clarify. Because this is as per this instructions, no demand has been received. You are trying to show it from a document that you have sent it.
Yes, ma'am.
Now can this court decide all this? You see, there is no denial or dispute as regards the pension entitlement
Yes,
of
yes.
the petitioner. If that be so, then there cannot be any delay in releasing it. How you do it, it is your headache. This court is not concerned with this. You cannot be both parties cannot now be throwing the buck on one another.
True, true,
That
ma'am.
cannot go on like this. I'm sorry. This cannot go on. From 2016, this petitioner is waiting for her pension.
It's
This is
not
a welfare
Only
state,
retirement benefit, Lordship, not pension, only retirement benefit. There is no provision for pension, Lordship.
retirement benefit.
Fine.
CPF, gratuity and Lordship leave salary, Lordship. No provision for pension. And amount is rupees.
What is to be done? Please come up with a solution. Otherwise, the officers of both sides has to be here.
So that my lord will put take another thing into consideration, whether my lord can a REIT court direct the government to pay them, my lord, for Supreme Court.
I am
very clear
not
this,
on
my lord.
that. I am not
My
on
lord,
that.
We are very clear, my lord, we just. give them
Mr. Dhar,
draft.
I am not on that. It is a 226 arms of this court is long enough to reach where there is injustice. This petitioner is waiting since 2016. You are saying it has not been given. They are saying they have sent.
My lord,
No,
This
we are not
cannot go
saying,
on
my lord,
like
it is On
this.
record, my lord.
What?
The
What?
letter is on record.
That is what you are trying to
My
say.
my lord-
Which page?
Page 43, my lord.
Page?
Page 43.
Page 43.
Is their affidavit, my lord.
Whose affidavit? Or what do you have to say from here?
Here, my lord, what I want to project is that we have sent the
No,
proposal.
one second. Mr. Dhar, what is this? Does it indicate that it has been sent? Because it says that has passed in order to submit supplementary demand proposal to the government for sanction and release of the entire retirement benefit of so and so. The total benefit of so and so arrives at so and so. The details are so and so. I therefore request you to kindly take necessary steps. Now this appears that this has been sent on 22/4/2024.
We do not, my lord,
You say you have not received this.
no, my lord, we do not pay individually, my lord, we pay as a whole, granting.
I have understood.
My lord will.
So, Mr. Dhar, I have understood that. So, according to you, this amount has already been sent to them.
Yes, my lord. This is in granting a
Correct.
adjust.
So then let me dispose of this petition by saying that since you have said that this
Yes,
has
ma'am.
already been given, so you give it to them within 3 months.
My
Let
lord,
me dispose
that-
it off.
That is what, my lord, this.
All right,
one-
Mr. Dhar, I think there is no difficulty in that order.
My-
Let me dispose it off as per your instructions.
My lord will quote this,
Yes, I'll quote this
yes, my lord.
on that basis.
The granting aid has already been.
Yes, I'll quote that, Mr. Dhar. 1 second. Heard MS P. Bhattacharya, Learned Counsel for the petitioner. Stop. Also heard Mr. R. Dhar, Learned Standing Counsel, Handloom and Textile, Standing Counsel, Finance. Also, no, and Textile. And Mr. P. Munir, P. Munir, right?
PK, my lord.
PK Munir, Learned Standing Counsel,
3 and 4, my lord.
Learned Standing Counsel?
Yes.
Learned Standing Counsel, Khadi and Village Industries Board. Junior Government Council, anyone there? Finance?
Please.
And Mr. P. Nayak, Learned Standing Council, Finance. But please inform, because generally I don't like recording someone's name if it's not available in the court, but he's generally here in this court. That is why I'm recording. So please inform, huh, Mr. Dhar? By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking her retirement benefits in full, which has been not released till date. Stop. It appears, no, you say that it appears from the order dated 2/4/2025 that on the submission of the Learned Standing Council representing the Assam Khadi and Village Industries Board, that a total amount of rupees 18,19,169 has been calculated to be payable as retirement benefit to the petitioner in terms of the communication dated 2/4/2024, and a supplementary demand proposal was going to be placed before the appropriate department of the government by the board for sanction of the said amount, comma. However, the amount calculated has not been paid till date. It appears that the respondent number 1, who is 1?
Commissioner Secretary, Handloom and Textile.
Within bracket, Commissioner Secretary, Handloom and Textile.
Textile.
Has filed an affidavit on 1/6/2024, wherein at paragraph 9 of the said affidavit, it has been stated that the last supplementary demand was placed in the State Legislative Assembly on 5/2/2024 and general budget of financial year 2024-2025 on 12/2/2024. It further appears from the aforesaid affidavit that it is stated that in case of any supplementary demand, it's stated that any supplementary demand will be possible in the coming monsoon season of the assembly due in the month of July of August 2024. Apt to refer to the relevant portion of the order dated 2/4/2025 for ready reference, quote unquote. You will get this order here at page 17 of order sheets. Just represented. Perusal reading of the aforesaid order, it appears that in view of the in view of the submissions made by the respective councils appearing for the parties, comma, respondent Learned Council appearing for the respondent numbers 3 and 4 was directed to obtain instructions as to how much granting aid has been received by the board during the financial year 2024 to 2025. And the Learned Council for the respondent number 1 was also directed to obtain instruction as to what had happened to the supplementary demand which was to be laid in the monsoon season of the State Assembly scheduled to be held in the month of July/August 2024. Thereafter, the matter came up before this court on 25/4/2025, wherein Mr. P.K. Munir, Learned Counsel for the respondent number 3 and 4, by placing an instruction dated 23/4/2025, which was kept on record and marked as X, submitted that a fund of rupees 10,000,70,000,000 has been received from the state government as GIA within bracket salary under general areas during 2024/2025. and a sum of rupees 10,070,700,000 was utilized during the aforesaid period. However, Mr. R. Dhar, learned counsel representing the so-and-so, that handloom and textile, submitted that he is still awaiting to obtain instruction as per the earlier order dated 2/4/2025. Accordingly, the matter was directed to be posted today. Today, when the matter has been called, Mr. R. Dhar, learned standing counsel, Handloom and Textiles, Sericulture Department, submits a correspondence dated 25/4/2025 to indicate that the grants in aid received by Assam Khadi and Village Industries Board during the financial year 2024-2025 is totaling to rupees 12,17,87,138. Correct? Stop. He further submits that no separate, he further submits that funds are not granted against an individual. Mr. Dhar, please hear this. Against an individual, but as a whole. And the claim of the petitioner is included in the fund which has been already granted, and it is for the board as how the said fund, it is the obligation of the board to utilize and release the fund to their employees. He further emphasized that it is not the obligation or responsibility to release individual funds, to release funds to individual employees of the board. Correct? Stop. This apt to reproduce a copy of the correspondence dated 25/4/2025, which reads as hereunder. This one, okay? And which is marked as Y. You mark for to Y, which is kept on record as marked as Y. Perusal of the aforesaid correspondence issued by the Secretary to the Government of Assam, Handloom, Textiles and Sericulture Department, Dispur. It appears that a fund of rupees 12,17,87,138 has been released to the respondent Khadi board.
If I may interrupt, madam, that amount, madam, 12 crore odd, madam, that is for the entire areas, madam. For general areas, it is 10.
I have not used anything. I have simply said total.
Is total.
I have used the
but
total.
the rest of it is amounts are divided,
You
madam.
see, this total is given to the board, right? So I have only said that.
PTAD for Karbi Anglong and North Kasar Hills, it is different.
You are for whom?
I appear for the board.
Correct.
For
So it is-
general areas, my lord, the amount
No,
is.
I have already reproduced the correspondence that would indicate. I am only
That may
saying
be
that.
clarified, my lord. That may be clarified. For
Why-
general areas, it is
All right.
10 lakh, 10 crore odd.
What did I write? To the respondent Khadi board. It further appears that as against general areas, a fund of an amount of rupees 10,070,000 was sanctioned and released to the Khadi board. Stop. It further appears that as per the aforesaid correspondence, no formal proposal is stated to have been received during the financial year 2024-25 for supplementary demand against the particular claim as per timeline fixed by the Finance Department. In this regard, it is worthwhile to refer. Yes, affidavit in opposition, which page it was? Mr. Munir, that page.
43, my lord.
43. And this is the affidavit filed by
By the handloom, my lord.
A1, respondent 1, right?
R1.
What did I say? Worthwhile to mention that in the affidavit in opposition filed on 1/6/2024 by the Secretary to the Government of Assam, Handloom, Textiles and Sericulture Department, Dispur, on behalf of the respondent number 1.
My lord, communication.
1 second.
Proposal Ahmad Mohammed. Head of
What did I say? The so and so stated as under, quote unquote, paragraph 9. That page 35. Okay. Page 35, you quote it. The letter dated 22/4/2024 referred in the above paragraph quoted above is also reproduced here under for ready reference, quote unquote, page 43. A perusal of the aforesaid affidavit and a perusal of the said letter indicates that the total retirement benefit of petitioner after calculation arrives at rupees 18,19,169.00. And accordingly, the respondent Khadi and Village Industries Board requested the respondent Handloom and Textiles Department to sanction and release the said amount for payment of retirement benefit of the petitioner. The submission of Mr. Today, interestingly, don't say that. It is also worthwhile to mention that the admitted retirement benefits, which is admittedly calculated and fixed at rupees 18,19,169.00, has not been released to the petitioner since her date of retirement, i.e.
31/3/2016.
31/3/2016.
2016.
The respondent Khadi board, being the authority to release the aforesaid retirement dues, is taking the stand before this court that unless and until the said amount is released from the respondent Handloom and Textile Industries, they are not in a position to make the payment. On the other hand, and also that they have already requested the respondent handloom and textiles industries for releasing the said amount. On the other hand, the stand of Mr. Ardhor, learned counsel for the Standing Council Handloom and Textiles, is that the department does not release specific fund, does not release fund for if a fund in the, what was that exact you said, individual
Yes, madam.
does not release fund
Fund for a specific.
for specific and for a specific employee of the respondent Khadi board. And he further submits that the funds as sought for has already been released in grant in need. That be that as it may, it appears that the petitioner is been running from post to pillar for her retirement benefits since 2016. Despite the retirement benefits being admitted, the same has not been paid paid to the petitioner till date. It shocks the conscience of this court as how the respondents are casually dealing the case of the petitioner whose retirement benefits for the last so many years have not been released, despite the same being admitted. This court is not concerned as how the respondent Khadi board is going to manage the fund in order to release the requisite, release the entitled retirement benefit of the petitioner. Without further going into the matter, this court deems appropriate to dispose of this writ petition. Please help me in this. Dispose of this writ petition in the interest of justice by directing the respondent Khadi board to release the admitted retirement benefit of the petitioner within a period of 3 months or 6 months.
Let it be 4, my lord.
Fair enough. Within a period of 4 months from today. It is needless to be clarified that the respondent Handloom and Textiles Assam shall cooperate and do the needful so as to enable the respondent Khadi board comply with the orders passed by this court as per law. That should be sufficient. Now you both decide what they are doing.
Well, earlier also, in the case, my lord, individually sanction was granted by the.
You see, Mr.
I'm not
Munir,
arguing on
you
that.
see, Mr. Munir, let us forget all
Yes.
this. Since you have Mr. Dhar doesn't say that you are not entitlement for fund. He doesn't say that. He is right. It is you how you utilize and pay. Now, if they have, they also doesn't say that this particular supplementary fund has been given. They are saying proposal has not come. On the other hand, you are saying that you have sent the proposal. This court is not going to go into all this. You sort it out. You have 4 months time. You sort it out, failing which you will have to face consequences.
Oblige.
Madam, partly heard this matter.
Hmm?
Last week the record was called for, madam. J.K. Goswami was appearing, madam.
Which is this matter? You see, this bench is now currently taking up these criminal matters under special statutes. I have completely. Huh? Alright, we'll let us have this matter next Thursday.
On 15 on Thursday.
Okay, on 15. All right. As heard, Mr. S. Thakur, learned counsel for the petitioner, none appears for the respondent on call. Relist on such and such date for further hearing.
15.
Is the lordship. That's
22-1.
and that's section 50, my lord.
Lordship, the last date of the order was, as per the order sheet, Lordship, 18/10/2024. And where it is stated that 18/10/2024, where it is stated that, Lordship, the charge will be framed on CC consideration of charge on 30/10/2024.
You don't have the updated.
Lordship.
No, but do you have the scan copy?
Can copy is there, Lordship.
Is the arrest memo and the everything is there for the
I
in
have
this?
flag mark the.
Have you seen all that?
I have not seen the arrest memo,
Have a
Lordship.
look at it. Because if Article 22(2) is violated, then
Lordship.
or
Yeah.
should we have this matter tomorrow so that you can check up if the charge sheet has been filed?
I will check it.
But you see, filing of charge sheet will be of no consequence if his
Charge sheet submitted.
no, that-
Only Lordship,
Charge sheet-
charge is not framed.
Charge.
charge not.
charge
Charge-
what?
It's of no consequence. The arrest, if it's illegal, is illegal.
Lordship.
So you have a look at it. If you want, I'll
Lordship,
take it
is
after.
there.
After
It is there, Lordship.
have a look. Have a look.
No, Lordship.
Very sad.
But the plea is not there, Lordship.
No, but
It is not in the petition, Lordship.
if it's not in the petition, if you want time, this court will give you.
Where's Lordship? I don't.
It's up to you. But this court is not going into the technicality that
Lordship.
since he has urged, but of course, I'm giving you an opportunity because the first condition of 37 is that you get full opportunity. Not only that, as for Bihan Kumar, when the point is urged, the onus is on you. So if they have not taken it in their pleadings, if they are taking it now, then if you are okay, we will hear you now. If you want time, we'll give you time. So you decide and tell me what you want to do.
Otherwise, arrest in the arrest memo, it is not there. It is true.
And the papers are before us.
Lordship, it is true.
One more judgment, I lordship has.
Heard Mr. N. J. Datta, learned counsel for the petitioner. also heard Mr. KK Das, learned APP for the state respondent. This is an application under section 483 of the BNSS 2023, seeking regular bail to the accused person, i.e. Molab Hussain, who was arrested on 9/6/2024 in connection with NDPS case number 316 of 2024, registered under section 22C of the NDPS Act so and so, arising out of Guwahati GRPS case number 130 of 2024, under sections 22C of the, don't say that, pending before the Learned Court of Additional Session Judge FTC number 3, Kamrup Metro at Guwahati. Stop. The brief facts of the case is that paragraph 2. Okay, page 2. Accordingly, the petitioner was arrested on 9/6/2024 in connection with the aforesaid case, and thereafter on 10/9/2024, he was forwarded to the court of Learned CJM, Kamrup Metro, Assam, along with a forwarding report, wherein the investigating officer has that's it, huh? Accordingly, the petition, present petition. Mr. Datta, learned counsel for the petitioner submits that the arresting authority, while arresting the petitioner, has not informed the grounds of arrest to him, and as such, the fundamental and constitutional rights guaranteed to him under Article 22(1) of the Constitution of India has been totally infringed by the arresting authority. He accordingly submits that the petitioner is entitled to be released forthwith. That is from this decision, that page, paragraph 4. Paragraph 4, same thing. Then 5. Instead of B. Sharma, it will be KK Das. So I am noting your submission as that you are indicating that the notice under 50 indicates that information as regards ground is given. That is your argument, right? But here, in this case, it was 47. Here it is 50, 50 CRPC. 50 CRPC. 6 as per this, 7 as per this, 8 as per this, 9. In 9, instead of section 47, you will say 50 CRPC and this pink flag. Okay. Then the same thing, 10, 11 is the arrest memo. You will find it here. Inspection memo is there. Inspection memo, pink flag. Para 13, same. Para 14 also same. 15 same. 16 same. 17. 18. Bail bond 50,000.
Moreover, Lordship, he is from West Bengal. So, sorry, Lordship, Tripura. So one local surety may.
Provided only with two sureties of like amount, provided that one surety has to be local and the other one has to be a government servant. Okay? Satisfaction of learned,
Learned, additional session judge, FTC number 3, Kamrup matter.
you got it? This is the bail application 382 of 2025.
And
Yes, Paul.
DPW.
Any similar?
But I have seen here, Lordship, it is stated here in the,
Where?
in the arrest, Lordship.
Next one.
Next one, 13, item number 13.
One second, let me finish this first. Document code 12. Next is 13.
13, Lordship.
Yes.
Certified additional affidavit, my lord.
Ah,
It is on record, my
Ah.
lord. So original certified copy I have annexed.
ah.
However, LCR is there, my lord. Page 35 is my additional affidavit.
Page.
5.
Arrest 30 to 38, I think.
38 is the notice, my lord.
You are hereby informed in written that you are arrested in connection with above noted case as sufficient evidence have been found against you involving to the case. The offense charged on you is non-bailable one. So you are forwarded to court custody on so and so, and the grounds of arrest communicated is communicated as per the provision of law. You may proceed to so and so. Yes, where communicated?
But it is stated here, Lordship, in other one it is not stated.
But where?
Lordship,
Communicated where?
Lordship.
This is not communication. Where are the brief particulars of
It
the
is not there, Lordship.
facts? Where are the facts constituting the
Particulars are not
offense?
there, Lord.
Unless you have any other document. Have you seen?
Other documents are not.
You have seen?
No.
And simply saying communicated and the grounds of arrest is communicated as per the provision. of law.
Grounds of arrest are communicated, it is stated only that, Lordship.
It will not be
No,
sufficient.
Lordship.
Scan copy, na? This is
Can open.
where Akut Assasa scan copy. So thus you have seen.
Lordship. Arrest memo I also have seen, action memo in it.
Even the remand order doesn't say. This will be again same, huh, OP? You are Mr. H.R. Chaudhary, right? Heard Mr. H.R. Chaudhary, learned counsel for the petitioner, also heard Mr. K.K. Das, learned APP for the state respondent. This is an application under section 483. I think everything will be same. I'm just giving you the detail. Will that be sufficient? Petitioner name is Mumit Ahmed. Arrested on 1/9/2022. Special NDPS case number 129/2022 arising out of Karimganj PS case number 525/2022. Registered under section 22C of the NDPS Act, so and so, pending at the court of Session Judge Karimganj.
Rebhumi, my lord. Now.
Huh?
Just Rebhumi.
At the court of Session Judge Sribhumi. Sribhumi, huh? Then the brief facts of the case is that
Page 14 is there, Payan. Page 14.
para 2,
Yes, ma'am.
huh? Page 3.
But in my petition, para 2, my lord.
Yes. So say that, and then after that, accordingly, a case was registered. and the petitioner, along with another co-accused, was arrested and forwarded before the CJM Karimganj on 2/9/2022. Stop. Thereafter, charge sheet was filed, and after charge sheet, after filing of these charge sheet, trial commenced. Paragraph 4 from this judgment. 4, 5, 6, 7, 8, then 9. Okay. 9. You 47, it will be 50 CRPC, huh? And you will get it at page 38. In the submission of Mr. Das, where you say indicate that information regards has been informed to the petitioner and the grounds and the ground of arrest is communicated. Just add that in his submission, huh? To the petitioner via the notice. That remains same. Just add that. Okay. Now, after you quote the 50 notice, after in paragraph 10 towards the end. Interestingly, it is mentioned in the said notice that the grounds of arrest is communicated as per the provision of law. However, upon careful scrutiny of the notice, there is no information whatsoever as regards the brief facts constituting the alleged offense. Then memo, arrest memo page
Next one, my lord, page 39.
39. Yes. Arrest memo, para 11, same. Okay. Arrest memo, page 39. Inspection memo,
Page 40, my lord.
para 12, same. Inspection memo, page 40. Para 13, same. Para 14. Para 15. (16). In para 17, after at the time of his arrest, no, in the present case, it is absolutely in the present case, except the noting in the section 50 CRPC notice to the effect that the grounds of arrest has been communicated to the petitioner as per law. There is nothing in the case diary, stroke case records, stroke materials available on record to indicate that such grounds have been communicated to the petitioner. Mere mentioning that the grounds of arrest has been communicated is not sufficient for the investigating officer to discharge the burden as regards compliance of Article 22(1) of the Constitution of India is concerned when the same is urged by the arrestee. Stop. Therefore, then you say it is absolutely clear. Okay. You want to say something, Mr. Parashar? Okay. Para 18, 50,000 and
A poor family, my lord. If any
securities. the same, with one from as a government servant disposed of.
Mileage.
Yes, Mr. Nawaz.
Under very sad circumstances, we come before your lordship, my lord.
Hmm.
The petitioner before your lordship,
So,
POXO, he was accused of POXO, section 6. On
Hmm?
the very first day, my lord, of his production, before the magistrate, before the concerned court, the petitioner raises the plea of juvenility.
huh?
Petitioner raises the plea of juvenility. Petitioner says that he is a juvenile. At the time of the incident, he was 17 years, some 10 months, my lord. The learned special judge initiates the inquiry, age determination inquiry. Now, your lordship knows whenever the plea of juvenility is raised, the court cannot proceed with the trial. First of all, the juvenility issue has to be decided. Now, in this case,
It is the CWC who has to determine.
big trial could not, because he has been produced as an accused before the,
There was a doubt as regards the age.
because he was produced as an adult. So he raised the plea of juvenility. So first of all, the first thing that the court has to do is to decide whether he is a juvenile or not. In this case, charge sheet gets submitted. Trial court lingers the juvenility inquiry and proceeds with the trial. Frames charges, examines all the witnesses. And my lord, what he does is, first of all, calls for the school headmaster. School headmaster comes.
This is a bail application.
I'm just submitting, my lord, the facts, my lord. Eventually, my lord, after
How are these facts relevant for
No, I'm-
considering whether this court should
No, no.
enlarge you on bail or not?
what had happened
The
was,
gravity of the offense.
yes, my lord. Eventually, my lord, what had happened?
Mr. Gogoi is not going to remain quiet for long.
Well, eventually, what the court did,
Hmm.
an ossification was directed. Ossification test revealed his age to be 16 to 18. Now, your lordship knows when the age is, it has to be.
See, that's why I'm saying I'm not here conducting the trial. I'm not going to give a finding to all
madam.
this. No, you address the court as regards the facts
Yes,
which
madam.
is required for considering your bail application.
No matter what I'm trying.
These are matters essentially of facts.
No
It
matter
is
what-
for the trial court to go into all this as
Madam.
regards your age
Yes, madam.
and everything.
No matter
It's
what
not
had
for
happened,
this
no,
court.
madam, what I'm trying to project is that subsequently I came before this honorable court. When the court did not consider me to be a juvenile, despite the finding, I came before this honorable court, I filed a revision. Now, this honorable court has already stayed the proceedings against me, my lord. Now, the trial was fixed at the case of argument. This honorable court has already stayed the proceedings. Now, proceedings against me are stayed.
In the revision, why didn't you pray for stay for bail?
No, because we were told that bail application has to be come in the form of a 483. So we have come under 483.
Revision was filed under what provision?
Under my lord, this current 443 and 447, my lord.
Of
Revision
of the new act.
basis of the new act, my lord.
That is corresponding to 482.
No, my lord, 397 and 397 and 401. my lord.
Earlier.
So there, my lord, this order was prima facie found to be illegal, and so the proceedings against me have been stayed.
How
Now,
long are you in jail?
well, for 1 year, my lord. It will be 1 year on 18th, my lord. I am in jail for 1 year. Proceedings against me.
What
have
is
been
the
stayed.
allegation? Where is the FIR?
FIR, your lordship will kindly come to page 21.
Rito on Bon Kurisa? It's a POXO case,
POXO
right?
case.
Video Bon Kurisa ne? Because yesterday I checked the live stream. You didn't switch off the. What is the stage?
Evidence only, Lordship. Evidence, harder evidence, Lordship.
Why was this matter fixed today?
Last occasion.
Yes, your worship, last time, just I think our prayer, I was not there, my lord, he was there, and your lordship put it.
Why was it fixed for today?
Further hearing, Miller.
A hearing for what? Something perhaps maybe it could be that one of you could have made a submission for update.
Last occasion, Lordship, Bankim Sharma had appeared.
That's what
Lordship.
I'm saying.
For
I
some
think
reason-
if otherwise it doesn't look why it has come up today.
Yes.
Most likely he wanted to check when is the next date, what is the position, because
That's the
out of
position.
25, only 6 has been examined. But do you have the scan copy?
Yes, can copies
If
there.
we find out what is the scan copy, does it show when is the next date? I think something he has submitted. Now I've forgotten.
Updated, Lordship, probably.
Probably because of that. This is a case arising out of
Yogi Gopa PSK.
Yogi Gopa, yes.
Offense, NDPS.
UAPA.
Yes.
Huh?
UAPA.
UPA. Yes.
Examined.
Last witness was examined on 21st March.
20,
1st March.
3, 25.
Yes.
Then probably did not.
Next date, next. Okay, go on. Next date may be there. Only.
They want a disposal lordship, then
Because I'm just thinking, generally, this court doesn't keep these matters for further hearing. Only, it appears perhaps that could have been a point.
yes, probably lordship.
Maybe.
Otherwise, lordship, co-accused in the similar case, lordship, has been rejected. The bail application is
Where,
rejected
where,
by
where?
coordinate bench. I have given the order, lordship. That is lordship, BA 3830/24, order dated 4/2/25.
नाम क्या है?
Saeed Ahmed. Saeed Ahmed.
Saeed Ahmed,
Yes,
4/2/25,
Yes.
just recently.
yes. That is, he is also one of the co-accused lordship.
এটার মধ্যে এটুক নাই।
Both are co-accused.
আচ্ছা, চাষিটো
সেটাও আছে নাকি?
lordship, Yogi Gopa 56/22.
Al Qaeda.
Saeed Ahmed, no? Oh, Saeed. Saeed Ahmed not in the FIR, my lord, but in the charge sheet.
That has been rejected by the coordinate bench.
Then 2.5 years.
In that order, lordship, probably 2 witnesses were
That time only 5 was examined. Now 6.
6. But lordship, there is a satisfaction that lordship, that UAPA.
Sorry.
There has
Yes.
to be a satisfaction.
Yes, sir, that is there.
Yes,
UAPA.
এখন দিয়ক না।
I know this was rejected. Ketia rejected, sir?
Body, something. 4/2/25.
4/2/25.
Lordship, otherwise, if they are praying for disposal, lordship, then only I will proceed, lordship, because
They are obviously going to try pray for that, Mr. Sharma.
if they want to update the records, lordship.
I don't think from March much,
Yes.
probably one more witness maybe.
One hour, right. Only one.
If you want, I can have it on Monday.
Yes, that's.
To them, lordship. Them, lordship. Otherwise, I am ready, lordship.
Otherwise, this court is not going to.
My lord, only
I-
I was going to see.
Inclined, Mr.
That's
Chaudhary.
my, I am not on that.
I-
Nobody is concerned about that. My only question, my lord.
I am not inclined. Pay provision.
43D.
Mr. Parasar, could you find out when is the next date?
Last 10/3/25, fixed on 21/3/25. Subsequently, one updated version came, my lord, regarding that 6 was examined on. Subsequent to that, my lord, nothing has come.
I think we need, I
So
don't
it
think.
means further
No,
exams.
we don't need anything. Yes, section
43D.
3D.
D. Capital D.
Tax to 83. UP 1820.
Lordship has found.
Yes.
Actually, 43D, lordship, notwithstanding anything. containing the-
43 capital D, right?
Yes, yes.
Capital B.
Yes, please read.
Lordship, 43D, I am placing reliance on the next page. Subsection 5.
Yes, please.
5. Notwithstanding anything contained in the code, no person accused of an offense punishable under chapter 4 and 6 of this act. 4 and 6, lordship, this section that has been attributed to the present petitioner falls under this chapter only, lordship. 4 and 6 of
It is
this.
similar to 37.
Yes, but there is a slight difference, lordship. Shall, if in custody, be released on bail or on his own board unless the PP has been given an opportunity of being heard on the application for such release. Next, lordship, provided that such accused person shall not be released on bail or on his own bond if the court, on a perusal of the case diary or the report made under 173 of the code, is of the opinion that there are reasonable ground for believing that the accusation against such person is prima facie true. There, Lordship, in the other act, Lordship, including the NDPS, that is different, Lordship. But this is
There is one more condition.
prima facie true. They are not guilty, Lordship. Their record satisfaction is.
No, here it is that there are reasonable grounds for believing,
Yes.
not prima facie.
And
That NDPS.
that also, Lordship, has been clarified further by the Supreme Court in one of the cases. I will produce it before your Lordship.
Yes, I'm hearing.
Lordship. Then, Lordship, I do not have a copy of the judgment, but it is, Lordship,
Okay, then Monday,
Yes, madam, that will be better, madam.
Monday. You get it Monday. Relist Monday dated on such and such.
sorry, Lordship, better on Tuesday, probably, Lordship.
Could you try for the updated scan copy?
Won't come, Lordship.
It will not be possible.
But only one fair, my lord. Can you get some copies of deposition, my lord?
Huh?
We'll get copies of the deposition, my lord. We'll have at our cost, my lord. In the office, my lord, they can give, by the way, at our cost, my lord.
You can have a look at it. You'll not.
Obliged.
But Mr. Sharma, you be there if this matter is fixed
Yes, yes,
here.
yes,
You be there.
yes, yes.
Otherwise, I'll forget.
Last occasion, Bankim Sharma was there.
No problem. This time you be there. Bhaskar Sharma.
Lordship.
Mr. Chaudhary, not only two, there are three B Sharmas as a APP.
Sharma remains same, my lord.
Yeah.
Last-
And three of them are B. Nah?
Vidut Sharma.
I think Mr. Gogoi wants this court to remain confused. That's why he has three B Sharma in the team. Yes,
Just to be plus Sharma, BK Sharma. my lord.
yes, please. Next. This is that IA which you had mentioned the other day. No. Hey, Rupa. Good. Yes.
That second appeal, RSO
One
was disposed of or closed on the ground of abatement.
on the ground of.
Because non-impleading or non-substituting the legal heirs of deceased referred to within time despite of the information, because we were the appellant, despite of the information under Order 22, Rule 10A. After the abatement, the number 3 herself came before this honorable.
No,
Yeah.
what is this IA? Is there a condonation application?
3 eyes are there.
No, is there a condonation
Yes,
application?
your lord.
Condonation for what?
Condonation for 379.
For what? For filing?
Filing an application for setting aside abatement.
So that has to be taken up first.
Because I'm coming on that, your lord.
Before that, they has to satisfy this court about the sufficient ground
For what?
in the condonation
Correct.
application.
Miss Counsel, this court knows the law. This court is merely saying that because there are so many IAs here. So
Lordship.
first the court has to decide the condonation IA.
Yes,
That's
Lordship.
all the court is saying. How, on
Taking-
what parameters the condonation application has to be decided, this court is fully aware, Miss Counsel.
No, Lordship, Lordship is saying that substitution has to be taken first or condonation, Lordship.
No, condonation,
Condonation, that is 1780, Lordship.
that has to, isn't it? That
Lordship.
has to be first taken.
Yes, Lordship. And
Because
we have
unless
filed
we
our-
condone,
Lordship.
the substitution question will not come. Will
Lordship.
it come?
No, Lordship. So in 1780 IA, we have already filed our objection. She is
1780.
arguing 1780, Lordship.
You're arguing
Submit, your
that?
lord.
1780, that is
Yeah.
the condonation application. But substitution of the,
Condonation application, sorry.
correct,
Now, in this
Yes, what
in
is the
this
ground
package,
of delay?
There's another application is also there, that is ISABL 659 of 2025. Objection has been filed, that is in para 10 of that application, objection, it has been that as the appellant number 4 prior to the filing of this, as that is mentioned in the year 2021, he was a deceased person, and as the name of a dead person has been added in the application, these applications are not. Now the peculiar situation, against that we have filed that IA under under order 1 rule 10(2) for striking of the name of the deceased person, as it was an inadvertent mistake. Now, what peculiar situation we are facing, because despite of the knowledge that appellant number 4 died prior filing, these legal errors, although present, we are not in till to date we are not being able to find out the addresses for substituting them in place. So, as he was a party in the added defendant and as he has contested in the suit, cannot be striken off, otherwise substituting the layers. So my humble prayer will be that, your lordship, can we get a last chance? At least we can get the, because I have informed the party regularly, I'm in touch.
You want time today?
At least one last time may be given that for the legal layers, otherwise the maintainability.
So how this court will give you that opportunity? There's no problem in accommodating you today, but condonation is not.
Only delaying the matter and our execution is pending, lordship.
Execution.
Anyway, you
part
take
by
instruction. As prayed for by MS SD Gupta, learned counsel for the applicant, relist this matter after 2 weeks
Yes, sir,
on a date to be fixed by the registry.
Lordship, this may be as a last chance already.
Yes,
two,
sir,
Alright.
lordship,
two
and the last
opportunity.
chance, your lordship.
Yes, next.
Obliged,
Whatever.
lordship.
Impleadment. Is this an impleadment application?
Implement.
First time? No. Who is appearing?
Last day also, my lord, they failed to appear because they have already sold the property. Plan. That includes the suit land.
All right, you want to implead whom?
They are the new parcels matter. During the pendency of this case, RFA, my lord, they have sold properties, my lord. I have given the list, my lord. Your lordship may be pleased to see at page 8, para 7. That during the pendency of the appeal, the respondent number 3 and 4 had illegally sold their
Sorry,
land.
para
7, page 8. Legally sold their land to the other person as such they are required
Mr. Gautam, that matter probably I'm going to get fix it on Thursday. That Pathard matter. Inform the other side also. That is item number. All right, Thursday. Further hearing due to possible. Yes, please.
Para 7, my lord. That during the pendency of the appeal, the respondents number 3 and 4 had illegally sold their land to the other person. As such, they are required to be implemented in the appeal as party respondents so that the appeal be heard in their presence. The persons who purchased the land may be implemented as respondent number 5.
All right. Third, Mr. P.K. Kalita, learned counsel for the petitioner. Senior counsel, assisted by Mr. K.R. Borwa, learned counsel for the applicant. None appears for the respondent on call. This application is filed. Mr. Counsel, please take your seat. This application is filed under Order 10(2) of the CPC 19(8) for impleadment of certain persons as respondents in the connected regular first appeal. Now, the brief facts of the case is that It appears that on the last occasion, i.e. 7/4/2025, also when the matter was called, there was no representation on behalf of the respondent, despite the name of the learned counsel appearing for the respondent being reflected in the cause list on both the occasions. On both the occasions, i.e. 7/4/2025 as well as today, as well as today. Matter is accordingly the matter is accordingly taken up for disposal. Brief facts fact of the case is that the applicant had preferred the connected regular first appeal against the judgment and decree dated 30/6/2014, passed by the Learned Civil Judge Senior Division number 2, Kamrup M at Guwahati, whereby the title suit number 396 filed by the predecessor of the applicant was dismissed. It appears that the predecessor of the applicant had filed the suit and consequently the connected first appeal against the respondents with regard to certain landed properties, which was allegedly sold to the above respondents by one late Najimul Islam, i.e. the predecessor of the respondent numbers 1A, 1B and 1C in the connected regular first appeal. Stop. It appears that during the pendency of the regular first appeal, the aforesaid land is alleged to have been sold by the respondents to other persons and as such, the present application has been filed for impleading the new purchasers. Mr. So-and-so, Learned Senior Counsel, submits that since during the pendency of the appeal, the subject land has been illegally sold by the respondents to four persons, the presence of the aforesaid four persons is essential and necessary for effective adjudication of the first appeal and accordingly seeks impleadment of them. Heard, perused. Apt to reproduce paragraph 5, 6 and 7 of the instant application, which reads as hereunder. Correct? Perusal of the aforesaid averments, it appears that during pendency of the first regular first appeal, third parties have brought certain plots of land, a certain plot of the disputed land, which is alleged to have been sold by the respondent to them. The names of the aforesaid persons are as under 1, 2, 3, 4, 5. By page 8 or by to me, huh? That being so, this court is of the considered view that the presence of the aforesaid persons is essential and necessary for effective adjudication of the matter. Accordingly, the aforesaid persons, the impleadment application stands allowed it is provided that নাম গিলা দি দিবা, huh? So and so এইজনের নাম দি দিবা, be implemented as respondent numbers 5, 6, 7 and 8 in the connected regular first appeal number 57 of 2014. Let an amended cause title be submitted before the registry of this court within a 1 week from within a period of 1 week from today for doing the needful. Stands allowed, huh?
It may be sent to them also, my lord.
That order has to be in
These
the
4 persons, my lord.
no, that order has to be in the RFA.
RFA.
Correct.
Yes, my lord.
The new, let you submit, huh? In the RFA. Should I say in the RFA list on such and such date? Then it will become easier.
Please summarize, my lord. It will be early.
All right, let me do it. In the RFA, you write that in view of the order passed on such and such date, in IAC 1128 of 2025, comma, let notice be issued to the newly implemented respondent number so and so, so and so, so and so, likoi diba. Steps by registered post AD within the period of 10 days from today, and
2 weeks, my lord, because after correction only.
10 days I have given.
Yes.
10 days or 2 weeks is too long. 10 days, you do it.
Yes.
10 days, huh?
Good.
List on such and such date. A list after 3 weeks on a date to be fixed by the registry. 3 weeks will be short. Should I make it 4 weeks?
Actually, it should be listed after the service of the summons, my lord.
4 weeks. 4 weeks. Which is this criminal appeal?
Lordship, this appeal is with regard to conviction with 304 Part B by the appellant's lordship to go under imprisonment for undergo imprisonment for 5 years, Your Lordship. Because the matter, Lordship, had the occasion to peruse the evidence. There were 22 number of witnesses, wherein in a village there was a ceremony, and the particular deceased person was seen by the witnesses to be taken away by a group of boys. And at the end of the day, on the next morning, he was found tied to a particular tree. And when he was hospitalized the day before, after that, he expired. That's the case where Your Lordship had the occasion to go through the whole evidence.
Thakur, I think, was there.
My lord,
Are you aware?
yes, the last order I have seen just checked in
I mean,
the.
are you prepared?
My lord, actually, I am not whole prepared, my lord.
You can have it on Tuesday.
My lord.
Okay, Mr. Das. Tuesday?
Yes, Your Lordship.
Tuesday or Thursday?
Thursday, Lordship.
Thursday.
Either me or P. Thakur.
Yes, one of you.
My lord.
Heard Mr. M.K. Das, Learned Legal Aid Counsel for the applicant. Also heard Mr. K.K. Parashar, Learned APP Assam for the state. This matter was part heard on the last part heard, no?
Yes, Your Lordship.
Pardon.
But why? Where is it mentioned?
Part
as
has, my
part
lord,
heard?
not mentioned in the order, my lord.
No, it is mentioned.
Earlier.
This matter
The date
was part heard before this bench. However, on the last occasion, Mr. P. Thakur, Learned APP Assam, was arguing on behalf of the state of Assam. Today, since as such, Mr. K.K. Parashar, Learned APP Assam, request a short accommodation to either assist this court on the next date of listing, to assist this court either by himself or by the concerned APP. Prayer is allowed. Relist on Thursday
Lordship.
on such and such day for the hearing.
My lord. The old building matter, my lord. Yes,
Hmm.
my lord, and it on my.
Who is appearing for the other side? All right, we'll have it on another date. Heard Mr. G. Uddin, none appears for the respondent on call. List on 13th or Pisarata DJ on such and such date.
My lord.
Comfortable 15?
And was present, my lord. He's
It's all right. Next, you have it on 15. Yes.
wait, please, your lord.
Here also, I think other side is not there.
Mr. J.I. Barbuya.
Heard Mr. N. Dhor, learned counsel for the applicant, none appears for the petition, respondent on call. When do you want it? List on
Read it home.
18, 17, 19,
My lord, I am here up to 18th, your lord.
17,
My lord, let it be a bit early,
16.
your lord.
16. Next.